Good afternoon. Good afternoon. It's almost 2 o'clock, I believe. And I'm here in DC. You can see next week it's going to go down. I only hope for the best. I'm not gonna be around this town next week, but I'm gonna be live for our live sessions. But I'm not gonna be like downtown DC because today there's a lot of I believe 24,000 people for the protest. So yeah, don't forget we have a live session November 4th, 5th, and 6th. We're going to talk about the future, immigration, of course, the plans, and we just hope for the best. By the way, today I was talking about marriage, green card based on marriage. We have a case where the spouse is a lawful permanent resident and the beneficiary is a student, F1 student. So here's the thing. If a person is a lawful permanent resident and gets married, the visa is not immediately available, which means you're going to have to file for I-130 first. Once it's approved and the visa becomes available, then you follow with the I-485, provided that the beneficiary is still within lawful status. If the beneficiary loses the status, what's going to happen is you're going to have to wait for the spouse, the petitioner, to become a U.S. citizen, and then we're going to follow with the green card application, sponsorship application, work permit application, travel advance parole application if the person wants to travel outside while the I-485 is pending. That's how it's just going to play out, because at that point the visa becomes immediately available if the petitioner is a U.S. citizen. If not, then you're going to have to wait. Becomes available, then you apply. So for the green card, provided that you still maintain lawful status, right? That's how it goes when it comes to green card based on marriage. Then we have another case where the other person is a J1 student. The question becomes, can I adjust status? Well, the answer is very simple. First of all, not as simple as you think, right? But the answer is straightforward. First of all, we have to make sure to double check whether you are under the 2 years residency requirement, which states that you have to be outside for 2 years prior to changing to another, prior to coming back to America to get another type of visa. So if you want to adjust status and you're under the 2-year residency requirement, you're going to have to apply for a waiver, provided that the waiver gets granted. There's a waiver of hardship, there's a waiver of asylum, fear of persecution, there's a waiver of medical one. I never talked about it, but someday I'll take the time to talk about it. So you have to double check and know, first of all, am I under the 2 years requirements? If not, then yes, you can adjust status. If you are, then you have to be able to get the waiver granted. You can also ask for a no objection letter. Maybe they can waive that for you in terms of your country of origin is not opposing you staying here. So that's just how it works. So again, my name is Bijoux Ngwanda. If you need a consultation with me, please don't hesitate. Please schedule it by using the consultation link on my bio profile. Everywhere we have a consultation link. We can get you in a Zoom meeting. You can ask your questions. That's how we do it. But if not, again, just join us next week, 4th, 5th, and 6th for live sessions. Until next time, bye-bye.